In this video, I'm going to be talking about a big mistake that even the most prepared people make at their restraining order hearings that can cause them to lose. And this applies actually maybe even to the most prepared people, and even people with attorneys, even attorneys themselves. So if you have a restraining order hearing coming up, stick around, because after you watch this video, I guarantee that you are going to have a much better idea of how to win your restraining order hearing. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you from start to finish everything that you need to know to represent yourself at your restraining order hearing and win. So if that is something that you are interested in, you can find your free first class via the link in the description box down below. Okay, so let's jump right in. What is the big mistake that so many people want to make, are tempted to make, that I've seen them make, that even attorneys make? It is not being prepared for a really short restraining order hearing. So let me explain. Restraining order courts are often really busy. There can be 25 cases on the calendar in a single morning, and the judge has to get through them. And actually, especially if you're the respondent, you want the judge to be able to get through them, because the consequence if they don't, which I've seen a lot of times in some counties, San Bernardino is really bad with this, is that you cannot have your restraining order hearing heard for months, and they will keep the temporary restraining order in place. So when a judge is faced with having so many cases on their calendar, one of the only things, maybe the only thing that a judge can do in this situation, if they want to keep their calendar under control, if they want to make sure that these temporary restraining orders don't stay in place for months at a time without the respondent even getting to tell their side, is to severely limit the amount of time that they spend on each case. When you're preparing for your restraining order hearing, you think, I want to give the judge all the evidence. You want to give this thing your best shot, right? And so you may feel like, I want to gather everything that I can. I want to show the judge everything about this relationship, all the problems with the other person, all the good things about me, all the reasons why what they're saying is true couldn't possibly be true. The problem is, the judge might tell you, once your case is called, that you only get 10 minutes. So if you were preparing this as though you had, an hour, or sometimes even longer, to present your side, to present your evidence, to present your testimony, and explain everything to the judge, and then the judge suddenly, right before you're about to start, tells you only have 10 minutes, you might feel blindsided, and you might be thinking, what am I supposed to show then? So here's what you should do. You should figure out your most important points and evidence first. Before you start preparing everything else, before you get together hundreds of pages of exhibits, if you are the respondent, read what the petitioner says happened. Read their allegations of abuse and figure out, how can you address each one? What are your most important points to address each one? And you do need to address each one. If whatever they're saying is completely made up, you at least need to deny it. You need to make sure that you address each one in your hearing. So what are your most important points? Start your outline there, and you can always add more later on. And save that initial outline that you make. So when you build on it as you are preparing, because you should prepare for more than 10 minutes if you have more than 10 minutes to address everything, right, and present your evidence. Save that initial outline. Keep it separate when you build on your outline. And that way, once you're completely in the weeds, going through all this evidence, you can go back and remember what is most important. What do you want to make sure that the judge absolutely knows if you only had 10 minutes? Now you might be thinking, but how am I supposed to know what's important? That's why I want to show the judge everything. They will know it's important, and I want to make sure I don't leave anything out. Okay, so this is something that I teach you, and I spend a decent amount of time on in the course, because before you start preparing any testimony or any objections or anything like that, you need to know, what is the judge looking for? So in a domestic violence restraining order hearing, what the judge is looking for is whether a restraining order is necessary to prevent the occurrence of future domestic violence. Okay, so let's go through examples of the type of evidence, including testimony, including what you are going to say, because that's evidence too. That is probably going to be the most important versus what is probably not going to be important. And of course, I'm talking about in general. I'm giving examples here. If there was some sort of incident of physical violence that the petitioner is alleging, and there was actually an incident where the petitioner was injured or where there was some sort of physical altercation, but you as the respondent acted in self-defense, that's incredibly important. Going step by step and explaining what happened and how you were acting in self-defense, and that you were not trying to hurt the petitioner. You were just trying to stop them from attacking you. That is going to be really important. If there was some sort of physical altercation, but it was an accident, you didn't mean to hurt the other person. Maybe you flail your arms around like I do sometimes if I'm trying to make a point, and the respondent was coming from behind and you smacked them with your hand and you had a ring on it that cut them in the face. You didn't mean to do that at all. You weren't being violent. Explaining that to the judge is going to be important. And self-defense, and explaining that, or accident, those are especially important if the petitioner has photos of injuries, right? If the petitioner has photos of injuries or evidence of other injuries, the judge needs you to address those and explain, if you know, how those occurred. What about the petitioner attacking you on other occasions? That can be really important if you are trying to explain that on this particular occasion that the petitioner is saying that you were abusive, you were just acting in self-defense. Because if the petitioner was physically abusive to you on multiple occasions, or even one occasion before that, then it makes it more likely that they were physically abusive to you in this situation. And, well, if you were the respondent, it's not about whether they were abusive generally. It is if it's about self-defense. So it makes it more likely that you are acting in self-defense on this occasion. If petitioner always slaps you during arguments, for example, and on this occasion you saw their hand coming and grabbed their wrist, and there are photos of bruises to their wrist, but it's just because you knew it was coming. They were about to slap you, right? You're about to get slapped in the face. Then it's really important, if you have photos of injuries to your face, redness to your face, if you have proof of that from other occasions, or even if you don't, if you can just testify to that and explain what happened, that is going to be really important because it supports that you were simply acting in self-defense as opposed to being abusive. If the allegation is that you wrote abusive texts or emails, but you were responding to abusive texts or emails from the other person. So let's say they text you, they call you a name, and you call them a name back. Then those texts probably are important because they are showing that you were not trying to necessarily disturb their peace. It also shows the judge that a restraining order might not be necessary to stop future texts from you to them if the only times that you ever sent them mean texts were when they sent you one first. Now let's talk about things that are not as important that I commonly see people trying to or thinking might be important and trying to use in court. Generally, and there are of course exceptions, the petitioner's bad behavior, drinking, cheating, using drugs, those are usually not going to necessarily be important here. Does it make them look bad? Sure, and you may be thinking, look, they were terrible in this relationship and I had to deal with so much. Okay, but if the petitioner is doing all this bad stuff that you're getting upset about, then the judge might start to think, okay, well, maybe you got so fed up that you were physically abusive. So not only is it not necessarily important, but it can actually be a double-edged sword there. The reasons for arguments. This is huge. A lot of people really want to litigate the whole relationship. They're tempted to, if they don't really know what the judge is looking for, they're tempted to explain all these arguments, get into the details. The petitioner left a trail of mud in the house and didn't take off their shoes, and I've told them 1,000 times and this and that. They does not want to hear that, and you do not have time for that. And the reason why the judge doesn't want to hear that is because it does not help them decide the issue of whether a restraining order is needed to prevent the occurrence of future domestic violence. Now, if you were suing the other party because they walked on your vintage cream rug with their muddy boots, then the judge would want to hear that. That would be important. But in a restraining order hearing, it's not. And especially if you only have 10 minutes, you want to keep that stuff out. Another thing is the petitioner being dishonest in completely separate areas. Now, especially if you don't have that much time, because if you do have more time, the judge might let you get into it and it might make them look bad and swing things in your favor. But if you don't have much time, them cheating on their taxes or lying to other people or lying to you about their whereabouts, that probably is not going to be as important. Now remember, these are just examples of things that are important, but overall, the message I want to make sure that you have here is that you need to prioritize. Make sure that you have basically an elevator pitch of, if you only have 10 minutes, what are you going to say? I hope you found this video helpful. And again, if you are planning to represent yourself in your restraining order hearing, it is possible to win. People go to these restraining order hearings and represent themselves and win all the time. It is like small claims court. It is kind of like Judge Judy in a way, depending on which courtroom you are in. Although you may not get as much time as sometimes people get on there. But you have to understand what the judge is looking for, how to present your evidence. And that is exactly what I teach you in the course. I teach you everything that you need to know. So if you are interested in that, you can get your free first class in the link. You literally have nothing to lose. And if you did find the video helpful, please don't forget to like, subscribe, and ring the bell. And follow me on TikTok, Instagram, and Facebook.